Okay, folks, let's do another one. This one, Writ of Quo Warranto. What is a Writ of Quo Warranto? Let's go. A writ of quo warranto was a legal action used to challenge a person's right to hold a public office or exercise a power, judges, exercise a power, derived from the state. It essentially acts by what authority? And I'll be soon putting up a video of me in court where the judge asked me literally 11 times, did I understand? Do you understand? I'm going to be asking the questions, and do you understand? And every time I said, no, I don't understand. And then he started, well, we're going to proceed. And I said, by what? I kept asking him, by what authority? By what authority? And then he was like, you say it one more time. And I'm going to, he said, you say it one more time. And I want to have you taken out or something like that. And I'm like, by what authority? And he said, take him out. And they grabbed me and took me out. But anyway, I was already in custody, by the way, on that case there. I was already in custody, and he just basically just took me out. They had arrested me, brought me in, tried to do the arraignment, and I wouldn't give it to them. And so I'm like, by what authority? So anyway, this right here is directly in line with that, and you'll see why he acted the way that he acted. All right, so it says, it essentially acts by what authority? Do you hold this position or power? This writ is typically filed when there is a question about whether someone is legally entitled to hold a particular office or franchise. Here's a more detailed explanation. Purpose. A writ of quo warranto is used to determine if a person's claim to a public office or franchise is legitimate and authorized. In other words, is your oath of office in place? Is it current? Was it done, administrated properly? All right. All these different characteristics, all these different criteria have to be in place for that judge's oath of office or prosecutor's oath of office. Mainly, we're talking about judges in this regard, even though you can use this for anyone that's holding any kind of public office. But we try to focus. We tend to focus on judges and prosecutors. But in this regard, we're talking about the judge. So are all those issues, matters in place? And not only in place, but are they in place properly? If not, then obviously they are masquerading as someone that they claim to be, judge, prosecutor, whatever, clerk, and obviously they can be removed out of office and or have charges filed against them, civil and or criminal. It's not about the person's performance in the office. You have to keep that in mind. It's not about their performance. You can't use this for about their performance, but rather their right to hold it in the first place. All right, hold that position. Origin. The writ originated in English common law and has been adopted in many U.S. states and other jurisdictions. Historically, it was used by the English crown to challenge claims to offices or franchises. Key considerations. Public office. A quo warranto action is typically used to challenge the right to hold a public office, whether it's a state, local, or other statutory office. Now, when you ask them the jurisdiction, there have been some judges who tried to articulate their jurisdiction, that weird jurisdiction that they're using, and they say, well, it's a statutory jurisdiction. If it's statutory, then this is covered. This covers that matter. All right, and all those courts, they deal in statutory jurisdictions. If they're not the Supreme Court, the true Supreme Court of America, then they are using statutory jurisdiction. All right, which is a hodgepodge of jurisdictions. Legitimate authority. The court question is whether the office holder has the legal authority to hold the office. Not for misconduct. Quo warranto is not the appropriate legal action to address allegations of misconduct or poor performance in office. Other legal processes are used for those situations. Okay, so examples or situations. A person might be challenged if they were not properly elected. We talked about that, about the bond and stuff like that. Also, as a judge, they weren't properly elected and brought into the office of a judge properly. And there's a couple of steps we'll probably do a video on that. Along with we'll do a video on the judicial code also. All right, the different parts of the judicial code and most of the stuff that they violate. Okay, so it says a person might be challenged if they were not properly elected or appointed to that to an office. A challenge could be made if an individual is holding two incompatible offices. All right. And of course we can go into that. Some, like for an example, one example would be, if a judge comes from like a family court judge or traffic, and they go into a criminal court, when they come into that office, when they come into that new court, they have to be sworn into that court. Every time they change, like family court to traffic, or the traffic to criminal, or criminal to family court, or whichever one, they have to, every time they enter into a new court, they have to be sworn in to enter into that court and to preside over that court. All right, so you got to make sure that they were sworn in properly, and that they have the proper credentials even to be in that court and handling those matters. Okay? All right, so the next one is, if a person is serving in an office after their term has expired. That's clear. That should be clear. A quo warranto action could be used to remove them. Okay? All right. How it works. A writ of quo warranto is filed with a court, often by the state's attorney general or a private citizen with standing. Okay? So, like, you're in part of the court case or whatever, or you have standing to be inside the courtroom dealing with the matter, you know what I'm saying? Then you can put that quo warranto in. The court then investigates the authority of the office holder. The court then investigates the authority of the office holder. Remember, I said this in other videos, the judge is not the court. The judge is there as a referee, a middleman, to make sure both sides are playing fair. The judge is there to ensure the honor of the court is not violated. The judge is not the court. The judge is not the court. I'll say it again. The judge is not the court. The judge is the referee. The judge is there to make sure both sides are playing fair. Most of these judges are not doing that. And that's in violation of Judicial Code 100.1, which is they are to be impartial. Okay? So, that's the situation with that. Okay. So the court will investigate the authority of that person. Okay? Whether they have the right to be there. And then they'll be removed if they don't belong there. If all the credentials aren't in place. If the court finds the office holder lacks the proper authority, the court can order their removal. There you go. All right, and this is a distinction from other writs. Quo warranto is distinct from writs like mandamus, and we're definitely going to do a video on the writ of mandamus, which compel a public official to act. It's kind of like a letter rogatory. Okay? Okay, so this is according to Carlton Fields. Now, what we're going to do here is we're going to end this video, as we always do. Assalamu alaikum to the Muslims. Islam to the Moors, Shalom to the Hebrews, Hotep to the Egyptologists, Namaste to the Hindus, peace be upon you to the Christians, and good morning to those who are just waking up to this knowledge. Good morning. You're welcome.